Good evening and welcome to Lawyers on the Line. I'm Eric Beyer, a partner of the Falsani Balmer, Peterson, Quinn, and Beyer law firm and this evening's moderator. Tonight's topic is automobile injury claims. Motor vehicle crashes are a leading cause of injury and death in our society. Everyone needs to know what their obligations and rights are when involved in a car crash. Tonight's panel include Jim Balmer of the Falsani Balmer firm and Jim Peterson of the Falsani Balmer firm. Please call us with your questions about automobile injury claims locally at 218-788-2844, or if that's long distance for you, call our toll-free line at 1-877-307-8762. All right, Jim and Jim. This question's for Jim. Let's start with you, Mr. Balmer. If somebody has, they're going to their insurance agent, what kind of questions should they ask to make sure that they're buying appropriate coverage? In Minnesota, for example.
Well, the first thing they need to know is what coverages are required. Now, their agent should know that, but just so they understand what they're getting for their premium, they probably ought to get a quick rundown of what the coverages are. Minnesota is a no-fault state, so medical payments and wage loss coverage is mandatory. We also have mandatory coverage for injuries caused by an uninsured motorist. And then, of course, there's the coverage that you think you're getting, which is the liability coverage for both bodily injury of another person and property damage. One thing about the property damage I want to add is most people don't buy enough of it. If they just get the minimums, they'll soon discover that that was a mistake, because most cars cost a lot more these days than most of us realize. And so they should probably jack up their property damage to $50,000 or even $100,000, and they also should ask what the extra bodily injury coverage will cost. Usually it isn't that much more expensive to get the best coverage. So those are the kinds of questions I would ask if I were going to my agent.
Jim Peterson, I mean, what's appropriate coverage for somebody to have? I mean, I suppose that could depend on what kind of assets somebody has, but what's generally a good rule of thumb?
I don't know if there's a rule of thumb. You'd have to ask your agent about that. But again, Jim's right. Find out what it costs to get added coverage. You know, the minimum coverage is $30,000 in Minnesota. Mm-hmm. That doesn't go very far. If you have, if you injure someone and they need shoulder surgery and 3 months of therapy and a couple of MRIs, and they're out of work for 6 months, you're in trouble because you don't have enough coverage. And just because that's your insurance limit doesn't mean that's all you're liable for. And for your own coverage, you definitely want to ask your agent about stacking your no-fault. The no-fault minimum is $20,000 for medical, $20,000 for wage loss, which your company pays if you're injured in an accident, regardless of fault in Minnesota. And that's nothing. That hasn't changed for, what, 30 years?
Yeah, I think it's
40 years?
75 or something like that.
And that, and it also, the maximum required by law is $250 a week for wage loss. And again, that hasn't changed for 40 years. You can stack your coverages by the number of vehicles on the policy, and it's not it doesn't increase the premium much at all.
So you should talk, if you have more than one vehicle in your house, you should say, Mr. or Mrs. Insurance Agent, tell me about stacking, and my understanding then is it doubles or triples based upon whether you have 2 or 3 cars, your no-fault coverage. Is that right?
Yeah.
Okay. Let's talk about no-fault for a little bit. Some people think that if this is a no-fault state, what does fault have to do with causing a car crash?
The original idea behind no-fault, and I was practicing law when it came into being, was to eliminate excess litigation. Too many lawsuits were being filed for claims that were considered to be too small to justify court time. So what the law did was have each one of us go to our own insurer to get our wage loss paid and our medical bills paid up to a certain point. And the idea was that it would all come out in the wash. If each company paid all of its own insured's wage loss and medical expense, then no one company would wind up having to pay an unfair share. A lot of us worry about, well, won't my premiums go up if I make a no-fault claim? Usually not, because again, this is built into the system. Now, you still have the right to make a claim for a serious injury, and the statute defines what a serious injury is. Usually one resulting in permanent injury or death, or significant wage loss, or significant periods of disability, or significant amounts of medical expense. So you still have a right to go into court if you have a serious injury. But for the smaller, more modest injuries, you look to your own insurer for payment of your medical expense and wage loss.
Okay. So let's talk about fault a little bit. If somebody else causes the car crash, what is considered a serious injury? Jim talked about those levels. Of what are the actual levels in terms of medical expense or?
Well, there's 3 thresholds, and if you satisfy any one of them, you're good. One is $4,000 in medical bills, not including diagnostic tests like MRIs or X-rays or something.
So if you have medical expense that with a chiropractor and go to physical therapy and it goes to $5,000, you've met that?
Assuming that a finder of fact agrees with that.
Okay, all right.
The second
technicals,
is
yeah.
the second is a disability of 60 days or more. Usually that means a disability from work or some major life activity. And the third is a permanent injury or disfigurement. So if you have a permanent injury to your neck or knee, or you've got a jagged scar going down your face, then that would meet the third prong.
Okay. Mr. Balmer, what are are there any differences between automobile injury law in Minnesota and Wisconsin?
Yes.
What are they?
In Wisconsin, the most significant difference is that Wisconsin does not have no-fault law. So there are no minimum thresholds that you have to satisfy in order to bring a claim against the at-fault driver if you're hurt in a crash in Wisconsin. There are a number of other differences that I think a lot of people would regard as minor, but they mostly relate to how your damages are calculated. I think the biggest difference is that Wisconsin is not a no-fault state and Minnesota is.
Okay.
There's some weird things too that are not intuitive. In Minnesota, you cannot bring in any information into court about whether you are wearing a seatbelt or not. Okay, so if you get sued by someone because they say they were hurt in an accident and they weren't wearing a seatbelt and got thrown through the windshield, you can't even bring that into court.
Why? I mean, what's the rationale?
It's an old law that hasn't really been kept up with the times,
Okay.
and there's some controversy about it. In Wisconsin, the defendant or the insurance company can hire an expert to say, well, 20% of your damages were because you weren't wearing a seatbelt, therefore you'd get 20% less.
Another difference is that in Wisconsin, the jury is informed that the defendant had insurance at the time of the crash. In Minnesota, the jury is not allowed to be told that there was insurance on the defendant at the time of the crash.
Well, let's talk about that. What are the chances? I mean, somebody gets in a car accident, they go hire a lawyer. What are the chances this thing's going to end up in front of a jury?
Usually these days, most cases, if they're sued out, if you hire a lawyer and you bring a lawsuit against the other driver, I think 4 out of 5 cases are settled out of court, maybe even 9 out of 10, depending on where you are. Only the most serious cases will wind up in front of a jury these days. So most of the time the case is settled.
Okay.
I think, correct me if I'm wrong, I think in the Duluth courthouse last year, there were fewer than 10 civil jury trials.
I don't know. I'm not going to argue the point. I certainly am in no position to deny that. I will say that for the last 20 years, in both the Douglas County Courthouse in Superior and the St. Louis County Courthouse in Duluth, the number of trials over bodily injury claims in a motor vehicle crash has declined steadily, so that probably the fewest number of such cases was tried in 2013. And going back 20 years to 1993, that's probably the largest number over the 20-year span. Each year, fewer and fewer cases are tried to verdict.
Any insight as to why that is?
Well, there's a number of things. First of all, there are fewer cases like this. Cars are safer. People don't drive drunk nearly as much as before. There are a lot of just kind of litigation barriers. It's very expensive to take a case to trial, and a lot of people just don't want to take that risk. And it goes both ways. Insurers don't want to take the risk either, I think.
Okay. We have a couple of calls that have come in. I suppose we'll get to those. Someone calls in and asks, can you be considered at fault if you are at a stop sign and you get rear-ended by another car? Can you be considered at fault? Can the insurance company say that it's your fault for that car accident? I think what we hear sometimes is that just because you're someplace, that means necessarily you're at fault. Is that true?
No, that's not true. But I have heard a number of insurance companies try to allege that the person who got rear-ended was at fault because of a quick stop. They stopped too soon.
Okay. Sure.
Yeah.
And or they were driving too fast, and that's why they had to stop too soon. I can't say I've never lost on that issue, but
Well, if I could add a couple of things.
Yeah.
One is that, interestingly, if you stop in the middle of the street unexpectedly, I think it's more likely that a Minnesota jury will still find the driver that runs into you more at fault than you are. But if you're in Wisconsin, a Wisconsin jury is more likely to blame the person that stopped unexpectedly in the middle of the street for no apparent reason. And I don't know why that is, but I know that's the way it is.
Could reasonable minds disagree with that, though?
Well, yeah, maybe the moderator has a different view. Who knows?
I tend to think that Minnesota and Wisconsin are more alike than you do, I think.
I think that could be,
Yeah.
but I have seen chains of cases out of the Wisconsin appellate courts discussing that, and they don't discuss it so much in Minnesota.
Okay, I suppose that goes to ultimately, how does a jury determine who would be responsible for a situation like that? I mean, what questions are the jury asked?
Well, the jury is asked whether each driver involved in a crash is negligent, which is the failure to use reasonable care. And in automobile cases, the standard of care is defined either by the traffic statutes, meaning 30 miles an hour is the speed limit, or stop sign means you stop, or by the common law, which says things like you have to keep a reasonable lookout. You have to use reasonable care in going through an intersection, for example, if it's not marked.
So you should see things that are obvious to you, kind of thing.
Yeah.
Yeah. Okay. All right. Another call from a question from a caller. If I'm in an accident in Wisconsin, if an accident happens in Wisconsin between two Minnesota drivers, do you get to make a no-fault claim?
If your car is principally garaged in Minnesota, even if you're in a collision in Wisconsin, you still are covered by the no-fault law. So the answer to the question is, yeah, you can still make a no-fault claim. Interestingly, in that situation that the caller posed, where you have two Minnesota drivers in a collision in Wisconsin, if the innocent driver seeks compensation from the at-fault driver, the innocent driver has the option of bringing the action in Wisconsin or against the at-fault driver back in his own home state of Minnesota. So depending on how he feels he's more comfortable or what's more convenient for him, the innocent driver can choose which state he'll sue it out in.
Okay. Another call, a question from a caller. When is the umbrella policy recommended? When should somebody get one?
Well, the umbrella policy is a policy that covers your liability, okay, when you are at fault and cause injury to somebody. And usually it'll apply either if you're in a car or if it's under your homeowner's insurance, like your dog bites somebody, or you have a big hole in your yard and the mailman falls in it, letter carrier falls in it.
You're dating yourself.
But it sort of is coverage that's above and beyond coverage you may have under a specific policy. So, for example, you may buy a $1 million umbrella policy. Why would you do that? Because you've got a 401k with $750,000 in it, or you've won the lottery, and no matter what your coverage is, you may have some assets that someone's going to go after. Some trial lawyer is going to say, wait a minute, that guy's got some money, I don't care what his insurance is.
Right.
So you'd want to have some extra coverage to protect yourself.
Okay. We have another question. If you have a car in your name, but the insurance for that car is being paid by someone else, and is in that other person's, the policy is, let's say,
The owner of the policy
Owner-
is different than the insured?
right, are you still insured as a driver if driving in the car and get in an accident?
The question is whether the car you're driving is listed as the car in the policy.
Right.
And presumably, yes, if it's listed as the car in the policy, then you're covered. Now, suppose you're 20 years old and you lived with your parents and you get in a car crash. Then under some circumstances, their policy may cover a resident relative in their household if that resident relative for some reason did not have insurance, or if that resident relative has insurance but there's not enough, then the parent's policy might step in as a secondary policy to cover additional claims.
Okay. What is the rule in terms of being covered under somebody else's car? For example, if I was driving your car and I caused somebody to get in a car accident, are you responsible?
Unless you stole it from me.
Okay. All right. And that means that the distinction is a permissive use, as I understand it.
Yeah.
I have a case involving that right now.
Well-
You're right, obviously, that if you operate my car with my permission and you crack it up and hit somebody on the way to the grocery store, then the policy covering the car steps in initially to pay the claim, and then after my policy limits are exhausted, if they are, then if you have a policy, that would then kick in. But if you've got kids involved, juveniles, then there are some circumstances under which there's coverage, even if permission was not explicitly given. They're called special circumstances. So the classic case was where a guy went to a golf club and left his car in the parking lot with keys in it, and it was known that there were kids that hung around the parking lot and that these kids couldn't be trusted to leave other people's stuff alone. And so somebody took the guy's car while he was playing golf because he left the keys in the ignition, got in a crash, and then they sued the owner of the car, who was out on the golf course at the time, and his insurance was held by the Supreme Court as obligated to pay the claim because special circumstances applied to trigger the coverage on the car, even though the kids took the car without the permission of the owner.
He should have known that something bad was going to happen
Right.
if he leaves his
It was
car.
foreseeable.
Yeah.
Yeah, there's another example involving a beer truck in South Minneapolis that was double parked, and the guys went in to have lunch, left the keys in the beer truck, and it was in a high crime area, and somebody stole the beer truck and cracked it up. Same thing.
Pretty typical. If there's a beer truck, somebody's going to try to steal it.
Yeah, well, yeah,
Right.
leaving the keys in a beer truck. Yeah.
Let's talk about texting. If somebody's texting and causes a car accident, does that change any of the analysis in terms of how a case is handled? Are they held to a higher, are they
Well,
punished somehow?
Here's how I think. If you're texting and you cause an accident, I think you're at fault. You're going to be found negligent. The question is, and I don't think this has been resolved by the courts, at least in Minnesota, since texting became kind of an add-on traffic crime, is does that make it a punitive damages situation? In Minnesota, you can be found liable for punitive damages if your conduct shows a willful indifference to the rights and safety of others. That's a very high standard. In most cases, you don't violate that standard. You can be negligent, you can be really negligent, you can be kind of reckless, but it's not a punitive damages claim. I think if you're texting, especially since the legislature has singled that out as bad behavior that we want to punish, you can get punitive damages from somebody who's done that. I think I screwed around my pronouns there, but
No, that's all right. I think we get it. Idea texting is bad.
Yeah.
and they ought to be. The idea is potentially you can get add-on damages to punish the person who caused the crash
Right.
because they were.
yeah, above and beyond the actual damages, you can get paid money as punishment.
And that concept's very clear as it relates to drunk driving. Is that right, Jim?
Well, you'd think.
Okay.
But not necessarily.
All right.
It is more difficult to get a judge in Minnesota, or Wisconsin for that matter, to agree that the jury can make a finding of punitive damages in the case of somebody who's been drinking and driving. Merely the fact that you've been drinking before you get behind the wheel and cause a crash is not in and of itself enough to support an award of punitive damages, according to most judges in Minnesota. You have to have some sort of pattern, some sort of proof that the driver knew that he was too drunk to drive, but nevertheless chose to do so.
Okay. All right. Here's a woman who calls in from Cloquet. If I'm a passenger in my husband's car and we get in a car crash, can I bring a claim against my husband, for example,
Sure.
if he's at fault?
Yeah.
Does it change at all? Well, she asked who I bring it against. I guess that depends entirely on the facts of the case.
But typically, you can bring a claim against your husband. He's right. Okay. And even though you're an additional insured on that policy, you can, and so it's kind of your policy, you can sue your husband under the same policy under which you're also a named insured.
Okay.
Perfectly legitimate in Minnesota and Wisconsin.
If my child is driving my vehicle, this is a caller from Hermantown. If my child is driving my vehicle and has other kids in the car and gets in an accident, who's responsible for any injuries the other kids may sustain?
Well, the child presumably would be an insured under the policy, so the child would be liable, but the insurance policy would cover the liability. The owner of the vehicle under a Minnesota statute is also liable, as we already talked about, for anyone who's using the vehicle with permission. So the parent would be liable as the owner of the vehicle also.
Okay.
And that's a situation where it's really a good thing if you've got an umbrella. Because if you've got a car full of kids and they all get hurt, that could be a very, very serious claim. And it's nice to have a lot of insurance if that happens.
Okay. Another call, hit by a car as a pedestrian. Driver did not have insurance. He does have, the pedestrian has his own auto insurance and is wondering if he needs to go back to his own auto insurance for medical care.
Yes, he goes to his own carrier for no-fault insurance for the medical bills and wage loss up to the $250 a week Jim mentioned at the beginning of the program, and he can make a claim against his own coverage for uninsured motorist coverage. And that's exactly what it's for. And then the caller might say, well, I don't want to have to pay an increased premium for making that claim. Typically, unless he did something to bring about his own injuries, an insurer is not going to increase his premium because of it. That coverage is there for him so that he can make the claim and be compensated for the carelessness of another person.
One of the things I always tell my clients is if your insurance has the ability to raise your premiums and there's nothing you can do about it. But it's as we see with all the advertising, it's a very competitive market, and I'm sure you can talk to your agent to shop around if that should happen. It's unfortunate, especially if you pay premiums that long without any problems. They're going to raise your rates. I'd shop around.
Yeah, go someplace else.
Sure. Weird thing is, there's so many fewer claims and so many fewer lawsuits, but our premiums don't go down.
That is weird.
That is strange. I wonder why that is.
We could have another show on that. have to invite Noam Chomsky on that one. Question, is eating while driving considered a legal distraction? Can you be liable in an accident as a result of it?
Sure, you bet.
Basically, it's reasonable person standard. If that contributes to it and you're not paying attention, that's it, right?
Yeah. I mean, you're distracted, whether it's by cell phone or texting or loud music or eating or drinking. It doesn't matter.
I've seen guys driving down the road reading the paper. Come on.
That's bad. Yeah, I think we kind of take that for granted sometimes because, so much of the time nothing happens, but it just takes a really fraction of a second, and lives are changed. So, I think it's a real problem. There's studies on it, I believe, with relating texting to drunken driving, and the impairment in terms of paying attention is similar. And I don't think people really realize that sometimes. Question, going down Lake Superior Street, there's a car parked illegally, and the car door swings open, and you have no room to stop. Who's at fault for that accident from a caller?
Well, given the circumstances the caller describes, if there's nothing you can do to avoid the crash, you are not legally at fault for the harm that results. It's that simple. And if the driver can prove that the door was swung open far too late for him to stop or to go around, Yeah, he'll be exonerated.
Let's go to tonight, driving up here. Let's say you smash into Jim because you're going 20 miles an hour down Niagara Court and, or excuse me, not Niagara Court, how about Main Street, under the speed limit, you go to a stop sign, you slide through it, and then you hit another car. Are you at fault?
Well, I think you are, because the speed statutes in Minnesota say that the speed limits listed are maximums, and you have to adjust for existing conditions. Now, that said, some juries in Minnesota will exonerate a person if the weather conditions were such that they don't believe he could have avoided the crash.
Okay, now we don't have much time left here, but rental car on vacation in Hawaii, for example, the agent says, do you want our extra special insurance? Let's assume you have insurance here in Minnesota. What do you do, Jim? Quickly, we got to wrap up.
I decline it. I'm covered under my own policy.
I'd ask my agent before I go on the trip, do I need the stuff that they've got on the rental car?
Great. All right. Well, that's all the time we have tonight. Remember, you can watch our show again online at wdse.org or at our law firm site, duluthtriallawyers.com. If you have additional legal questions, you can access the Volunteer Attorney Program's Ask an Attorney service. Please join us next week when we'll be talking about premises liability. I'd like to thank our two panelists for their expertise this evening, and thank you for watching. I'm Eric Beyer. Good night.